I knew something was wrong the moment I saw the orange construction cones lining my driveway on that humid Tuesday morning in Charlotte, North Carolina. My name is Brian Zimmerman, and I had lived in the Meadowbrook Hills subdivision for 6 years without any major issues. Sure, the HOA was a bit pushy about lawn maintenance and mailbox colors, but nothing that made me want to move. That was about to change. The slope in question sat on the eastern edge of my 2-acre property, a steep incline covered in native grasses and wildflowers that I had carefully maintained since purchasing the home. It was beautiful in the spring when the purple coneflowers bloomed, and it provided a natural privacy barrier between my house and the community walking trail below. The property line had been clearly marked when I bought the place, with survey stakes driven into the ground and orange paint marking the boundaries on the trees. I was heading out for work at the software company where I worked as a senior developer when I noticed a crew of workers gathered near the bottom of my slope. A small excavator sat idling on the walking trail, its diesel engine coughing black smoke into the morning air. I pulled my truck to a stop and got out, my coffee still steaming in the cup holder. "Hey, what's going on here?" I called out to the nearest worker, a sunburned guy in a neon yellow vest who was studying a set of blueprints. He looked up, squinting at me in the early morning light. "HOA project. New parking area for trail access. Should be done in about 2 weeks." My stomach dropped. "This is my property. You cannot build anything here." The worker shrugged and pointed toward a white sedan parked near the trail entrance. "You will need to talk to the HOA lady. She is over there." I walked over to the sedan, my heart rate increasing with each step. A woman in her late 40s with short blonde hair styled in what I could only describe as a speak to the manager cut was standing next to the car, talking on her phone. She wore a crisp white blouse and khaki capris with oversized sunglasses perched on her head despite the overcast morning. "I will call you back," she said into the phone when she saw me approaching. "Can I help you? I am Brian Zimmerman. I own the property right there." I pointed up the slope. "And I need to know why there are construction workers on my land." The woman's expression shifted from neutral to condescending in a fraction of a second. "I am Sharon Hendricks, HOA president, and that is not your land. According to our community plat, that slope is common area property designated for community use." I felt my jaw tighten. "That is absolutely incorrect. I have the survey from when I purchased the home. That slope is entirely within my property boundaries." Sharon crossed her arms. "Well, the HOA has different documentation. We have been planning this parking area for 8 months. It went through all the proper approval processes. If you had attended the meetings, you would have known about it." "I did attend the meetings," I said, my voice rising slightly. "There was never any mention of building on my property because it is my property." She pulled out her phone and began scrolling through something. "Here. This is the plat filed with the county in 1998 when this subdivision was first developed. It clearly shows this area as common space." She held the phone toward me, and I looked at the small image on the screen. It was difficult to make out the details on the tiny screen, but I could see lines and demarcations that supposedly supported her claim. "I want to see the full document, not just a photo on your phone," I said. "And I want to see the county records, because my survey, conducted by a licensed surveyor in 2019, shows something completely different." Sharon sighed dramatically. "Mr. Zimmerman, we do not have time for this. The project is approved and funded. If you believe there is an error, you can file a formal complaint with the HOA board, and we will review it at our next meeting." "When is the next meeting?" 3 weeks from yesterday." So you are going to continue construction on what might be private property for 3 more weeks before even discussing it. She put her sunglasses on, even though the sun still had not come out from behind the clouds. The project is moving forward. Good day, Mr. Zimmerman. I stood there, watching her get into her white sedan and drive away, feeling a mixture of anger and disbelief. The construction workers had already begun marking areas with spray paint, outlining where the parking spaces would go. I got back in my truck and called my office, letting them know I would be working from home. There was no way I could concentrate on code while this was happening. Instead, I spent the morning digging through my filing cabinet until I found the survey documents from my home purchase. The papers were clear as day. The entire slope was within my property boundaries, with the measurements and bearings all professionally documented and stamped by a licensed surveyor named Robert Chen. I scanned the documents and sent them via email to the HOA board email address, along with a formal notice to cease and desist any construction on my property. Then, I called Robert Chen's office. The receptionist informed me that Robert had retired 2 years ago, but they still had all his old files and records. I scheduled an appointment for the following day to come in and discuss my property boundaries. For the rest of that day, I watched from my deck as the construction crew worked. They had begun excavating the slope, cutting into the hillside to create a level area. The sound of machinery filled the air, and I documented everything with photos and videos on my phone. My wife Jessica would have known exactly what to do, but she had passed away from cancer 3 years earlier, and I was still figuring out how to handle things like this without her steady advice. That evening, I attended the neighborhood Facebook group for Meadowbrook Hills, where someone had already posted about the new parking area construction. Most of the comments were positive, with people excited about having easier access to the walking trail. I posted my own comment, explaining that the construction was taking place on private property without permission. Within an hour, Sharon had responded publicly. Mr. Zimmerman, spreading misinformation about approved HOA projects is a violation of our community guidelines. Please refrain from causing unnecessary drama. The parking area is being built on common area property, and all proper procedures have been followed. Several people liked her comment. A few others came to my defense, asking reasonable questions about how the property lines had been verified. Sharon responded to none of those questions, but she did post a link to a community plat map that looked official at first glance. I downloaded the map and studied it carefully. The document was dated 1998, and it did show a small common area along the trail. However, the boundaries did not match the actual geography of my property. The slope was much longer than what the plat indicated as common area. Either the plat was drawn incorrectly, or someone had deliberately misrepresented the boundaries. The next morning, I drove to the surveyor's office in downtown Charlotte. The company had moved to a newer building since Robert Chen's retirement, but they still maintained all the old records. A young surveyor named Amanda Pearson met with me in a small conference room. "I pulled the file after you called," she said, spreading several large documents across the table. "Mr. Chen was very thorough. He did a complete boundary survey of your property, tied into the county coordinate system with GPS equipment. There is no ambiguity here. Your property extends all the way down the slope to within 15 feet of the trail itself. The HOA is claiming that slope is common area," I explained. "They are building a parking lot on it right now." Amanda frowned and pulled out another document. "This is the subdivision plat from 1998. Let me overlay it with your survey." She used a transparent sheet to show how the two documents aligned. See here. The common area ends about 60 feet up the slope. Everything above that is private property, divided among the lots on your street. So they are definitely wrong. Completely wrong. And if they are building on your property without permission, that is trespassing and property damage. You should contact an attorney. I thanked Amanda and asked if she would be willing to provide expert testimony if it came to that. She agreed and gave me copies of all the relevant documents, along with her professional opinion in writing. My next stop was the Mecklenburg County Register of Deeds office. I wanted to see the original plat and any subsequent amendments or surveys filed with the county. The clerk helped me locate all the relevant documents, and I spent 2 hours in the research room, photographing every page. The picture became clearer as I worked through the files. The subdivision had been developed in 3 phases between 1998 and 2003. My property was part of Phase 2, completed in 2000. When Phase 2 was developed, a new survey had been conducted that modified some of the boundaries from the original Phase 1 plat. The common area near the trail had been reduced significantly to allow for larger residential lots, which commanded higher prices. The HOA, however, was apparently still using the outdated 1998 plat that showed the larger common area. Whether this was an honest mistake or deliberate deception, I could not tell yet. But I now had incontrovertible proof that they were building on my private property. I drove home to find that the construction crew had made significant progress. They had cut a deep shelf into the slope, removing probably 20 cubic yards of soil. The damage to my property was substantial and getting worse by the hour. I walked down to the construction site with my folder of documents. The same worker from yesterday was operating the excavator. "I need you to stop work immediately," I said, raising my voice over the machinery noise. He shut down the engine. "I really cannot do that, man. I have a contract with the HOA. And I have proof that this is private property. You are trespassing and causing property damage." I showed him the survey documents. He looked at the papers, then pulled out his phone. "I need to call my boss." While he made the call, 2 other workers gathered around to see what was happening. The excavator operator's conversation grew heated, and I could hear a man's voice shouting through the phone speaker, though I could not make out the words. "My boss says we have a contract, and we are going to finish the job," the operator said finally. "He says you need to work it out with the HOA. If you continue working, I will call the police and report you for trespassing and property destruction." The worker shrugged. "Do what you have to do, man. I just work here." I pulled out my phone and dialed the non-emergency police number. Within 20 minutes, a Charlotte-Mecklenburg police officer arrived. Officer Davis was a tall black man in his 30s who listened patiently as I explained the situation and showed him my documents. "This is really a civil matter," he said after reviewing everything. "I can see you have these surveys showing it is your property, but the HOA apparently has documents saying it is their property. A judge is going to have to sort this out. But can they continue damaging my property while we wait for a court date?" I asked. "That could take months." Officer Davis walked over to the construction crew. "Guys, I am going to have to ask you to cease work for now. There is a legitimate property dispute here, and you could be held liable if it turns out you are working on private property without permission." The excavator operator called his boss again. This time the conversation was shorter. "He says we are going to wait for legal clarification before continuing," the operator told us. It was a small victory, but at least the damage would not get worse while I figured out my next move. Officer Davis gave me a case number and suggested I contact an attorney as soon as possible. That afternoon, I called every real estate attorney in Charlotte until I found one who could see me the next day. Martin Brooks had been practicing property law for 25 years and had dealt with numerous HOA disputes. His office was in a converted house in the Dilworth neighborhood, and he met me wearing jeans and a polo shirt, explaining that he usually worked from home but came in for client meetings. "This is pretty cut and dry," Martin said after reviewing my documents. "They are building on your property. The question is whether it is worth the time and money to fight them in court, or whether you want to try to negotiate a settlement." "What kind of settlement?" I asked. "Well, they have already damaged your property. You could ask them to restore it to its original condition, which would cost them tens of thousands of dollars. Or you could negotiate an easement agreement where you allow them to use the land for the parking area in exchange for compensation. Or you could demand they stop entirely and sue for damages." "I want them to restore my property," I said. "That slope took years to establish the native plantings. It provides privacy and erosion control. I do not want a parking lot there." Martin nodded. "Then we file for an injunction to stop all construction, followed by a lawsuit for trespass and property damage. I will draft a demand letter today, and if they do not respond appropriately within 10 days, we will file in court." "How much is this going to cost me?" "I will need a $5,000 retainer to start. Depending on how much they fight it, total costs could range from $10,000 to $50,000. But if we win, which I think we will, you can recover your attorney fees and costs from the HOA." I swallowed hard. It was a lot of money, but I did not see another option. They had damaged my property and showed no intention of backing down. I wrote the check. Martin moved quickly. By the end of the day, he had sent a detailed demand letter via certified mail and email to Sharon Hendricks and the entire HOA board. The letter laid out the facts, included copies of the surveys, and demanded that the HOA immediately cease all construction, restore the property to its original condition, and pay damages for the destruction already caused. The response came 2 days later, and it was not what I expected. Instead of backing down, the HOA doubled down. Their attorney, a firm called Morrison and Associates, sent a letter claiming that the HOA had valid title to the common area based on the 1998 plat, that my survey was incorrect or fraudulent, and that I was interfering with a legitimate community improvement project. They threatened to fine me for violations of HOA covenants and to put a lien on my property if I did not pay. "They are bluffing," Martin said when I forwarded him the letter. "Their position is completely without merit. We file the lawsuit." Martin prepared the complaint, and we filed it in Mecklenburg County Superior Court. The lawsuit named the Meadowbrook Hills Homeowners Association, Sharon Hendricks personally, and the construction company as defendants. We sought an immediate temporary restraining order to stop any further construction, followed by a preliminary injunction hearing. The judge assigned to our case was Judge Patricia Morrison, no relation to the HOA's attorneys. She reviewed our emergency motion for a TRO and scheduled a hearing for 3 days later. In the meantime, the story had spread through the neighborhood. The Facebook group was in chaos, with people taking sides. Some neighbors came by my house to express support and to share their own horror stories about the HOA's overreach. Others left notes in my mailbox calling me selfish and accusing me of blocking community improvements. Sharon made everything worse by posting regular updates on the Facebook group, framing me as an unreasonable neighbor who was trying to stop a project that everyone else wanted. She never mentioned the property line dispute or the surveys. She just kept saying that I was causing problems over a technicality. One evening, I was grilling dinner on my deck when my neighbor from across the street, Tom Bradley, came over with a six-pack of beer. "This is insane," Tom said, handing me a bottle. "I looked at your surveys. That is definitely your land." "Tell that to Sharon," I said. "Sharon is on a power trip. She has been HOA president for 6 years, and it has gone to her head. Last year, she fined me $300 because my mailbox was the wrong shade of black. I had to get a color meter to prove that it matched the approved color chart. Why do people keep electing her? Nobody runs against her. Most people do not even know when the elections happen. She controls the information, so she controls the board." Tom stayed for dinner, and we talked about neighborhood politics and HOA horror stories from around the country. It felt good to have someone on my side, even if it was just for moral support. The TRO hearing arrived quickly. Martin and I sat at the plaintiff's table while the HOA's attorney, Richard Morrison, sat with Sharon at the defense table. Richard was a silver-haired man in an expensive suit who looked completely comfortable in the courtroom. Judge Morrison reviewed the pleadings and then asked Richard to present the HOA's position first. "Your Honor, this is a straightforward case of a homeowner trying to block a community improvement project that was properly approved through the HOA's governance procedures. The parking area is being built on common area property as designated in the subdivision plat filed with the county in 1998. Mr. Zimmerman's survey, conducted 20 years later, does not supersede the original plat." The judge turned to Martin. Response. "Your Honor, with respect to counsel, the 1998 plat was superseded by a revised plat filed in 2000, when Phase 2 of the subdivision was developed. That is the phase that includes my client's property. The 2000 plat clearly shows the reduced common area and expanded private lots. Furthermore, my client's survey from 2019 was conducted by a licensed surveyor using modern GPS equipment tied to the county coordinate system. It is accurate to within inches. The HOA is relying on an outdated document that no longer reflects the actual property boundaries." Martin presented the court with copies of both plats, the survey, and a color-coded overlay showing the discrepancy. Judge Morrison studied the documents for several minutes. "Mr. Morrison, are you aware of the 2000 amended plat?" Richard looked uncomfortable for the first time. "Your Honor, I was not aware of that document until just now. I will need time to review it with my client." "The document has been on file with the county for 25 years, Martin said. "It is publicly available information." Judge Morrison nodded. "I am going to grant a temporary restraining order, prohibiting any further construction on the disputed area, pending a full hearing on the preliminary injunction. That hearing will be set for 3 weeks from today, which should give both parties time to fully research the property records and prepare their cases. Mr. Morrison, I strongly suggest you and your clients review the 2000 plat and any subsequent surveys before that hearing." Sharon looked furious as we left the courtroom. She tried to approach me in the hallway, but Martin stepped between us. "All communication goes through me now," Martin told her. "Do not contact my client directly." "This is ridiculous," Sharon said. "The entire community is going to suffer because of his selfishness. The entire community is going to suffer because you did not do basic due diligence before building on someone else's property," Martin replied. We walked out of the courthouse, and I felt a weight lift from my shoulders. The construction was stopped, at least temporarily, and the judge seemed to understand that we had the stronger case. Over the next 3 weeks, several things happened. First, the HOA hired a surveyor to conduct their own survey of the property. The surveyor came out twice, spent hours taking measurements and setting up equipment, and then filed a report that confirmed everything my survey had said. The common area ended 60 feet below the construction site. Everything the HOA had excavated was on private property. Second, several other homeowners on my street checked their property surveys and discovered that their lots also extended farther down the slope than the HOA had been claiming. The HOA had apparently been treating a large section of private property as common area for years. Third, the construction company filed a motion to be dismissed from the lawsuit, arguing that they had simply been contractors following the HOA's instructions and had no independent knowledge of the property dispute. Martin agreed to dismiss them without prejudice, meaning we could add them back if needed. Fourth, and most interestingly, I received an anonymous letter in my mailbox. The letter was typed on plain paper with no signature, but it contained explosive information. According to the anonymous writer, Sharon had known about the property line issue before construction began. A previous board member had raised concerns about the boundaries at a meeting 8 months earlier, but Sharon had dismissed those concerns and pushed the project forward anyway. The anonymous letter included meeting minutes that had never been distributed to the general membership. Martin submitted the meeting minutes as evidence, and we subpoenaed Sharon to testify at the preliminary injunction hearing. The hearing was scheduled for a Tuesday morning, and the courtroom was packed with neighbors, some supporting me and others supporting the HOA. The local news had even picked up the story, and a reporter from Channel 9 was in the back row with a camera crew. Richard Morrison started by calling Sharon to testify. Under oath, she maintained that the HOA had relied on the 1998 plat in good faith and had no knowledge of the 2000 amendments until after construction began. When it was Martin's turn to cross-examine, he produced the anonymous meeting minutes. "Mrs. Hendricks, do you recognize this document?" Sharon's face went pale. "I have never seen that before." This is listed as the minutes from the HOA board meeting on March 15th of this year. It shows that a board member named James Patterson raised concerns about the property boundaries of the proposed parking area. Do you recall that discussion? I do not recall that specifically. According to these minutes, which I should note have the HOA's official header and formatting, Mr. Patterson suggested hiring a surveyor before proceeding with construction. The minutes indicate that you dismissed his concerns and said that the project had been planned for too long to delay it further. Do you deny saying that? Sharon shifted in her seat. Those minutes are not official. They were not approved by the board. So you do remember the meeting now? I remember that there was some discussion, but it was determined that a survey was not necessary. Martin pulled out another document. I have a statement from James Patterson, who resigned from the board 2 months ago. He states that you refused to allow the survey discussion to be included in the official minutes, and that you told him to stop causing problems, or you would fine him for violations of HOA rules. Is that true? Richard Morrison objected, but Judge Morrison overruled him and told Sharon to answer. James was not a team player, Sharon said. He was constantly questioning decisions and slowing down progress. So you did suppress his concerns about the property boundaries. I did not suppress anything. I made an executive decision based on the information I had. Information that included an outdated plat from before the plaintiff's property was even developed. Sharon did not answer. Martin continued his cross-examination for another 30 minutes, systematically dismantling Sharon's credibility. By the end, it was clear that she had known there were questions about the boundaries, but had chosen to ignore them because she wanted the parking area built. Then Martin called me to testify. I explained how I had discovered the construction, how I had immediately objected and provided survey documents, and how the HOA had proceeded anyway. I showed photos of the damage to my slope and explained how the native plantings had been destroyed. "Mr. Zimmerman, why is this slope important to you?" Martin asked. "My wife and I planted those wildflowers together," I said, my voice catching slightly. "She passed away 3 years ago from cancer. Every spring when those flowers bloom, it is like having a small piece of her still here with me." The HOA did not just destroy some grass. They destroyed something irreplaceable. I saw several people in the gallery wiping their eyes, including a few who had been posting negative comments about me on Facebook. After closing arguments, Judge Morrison did not even take a recess to consider her ruling. "I am granting the preliminary injunction," she said. "The evidence is overwhelming that the construction site is located on the plaintiff's private property. Furthermore, I am deeply troubled by the HOA's failure to conduct proper due diligence before beginning a major construction project, and by the evidence suggesting that concerns about property boundaries were deliberately suppressed. The HOA is hereby ordered to cease all construction on the disputed area, to restore the property to its original condition at their expense, and to pay the plaintiff's attorney fees and costs to date. A full trial on damages will be scheduled separately." Sharon stood up abruptly. "This is outrageous. You cannot do this to a homeowners association that is just trying to serve its community." Judge Morrison fixed her with a hard stare. "I can and I have. And Mrs. Hendricks, I strongly suggest you control your temper in my courtroom." Outside the courthouse, the Channel 9 reporter thrust a microphone in my face. "Mr. Zimmerman, how do you feel about the judge's ruling?" "I feel relieved that the law is being upheld," I said. "I never wanted this fight. I just wanted to protect my property and my wife's memory." That evening, the story aired on the local news. They had done their homework, interviewing other homeowners who had been fined or harassed by the HOA, and painting a picture of an organization that had lost sight of its purpose. Sharon declined to comment on camera, but they showed footage of her storming out of the courthouse. The fallout was immediate. Within days, 3 members of the HOA board resigned, citing their discomfort with how the parking area project had been handled. A petition began circulating calling for Sharon's removal as HOA president. The petition needed signatures from 40% of homeowners to trigger a special election, and it reached that threshold in less than a week. Meanwhile, the HOA's insurance company got involved. They sent their own attorney to assess the situation, and after reviewing the case, they determined that the HOA's actions were not covered by their liability policy because the property damage had been caused by intentional disregard of known risks. This meant the HOA would have to pay for the restoration of my property out of their reserve fund. The cost estimate for restoration was staggering. Because of the extensive excavation, the slope would need to be rebuilt with proper engineering to prevent erosion. The native plantings would take several years to fully re-establish, so the restoration company would need to use mature plants and install irrigation systems. The total estimate came in at $85,000. At an emergency HOA meeting, held in the community clubhouse, the membership erupted when they learned that the reserve fund only had $60,000. To cover the restoration costs and the attorney fees, the HOA would need to levy a special assessment of $700 per household. "This is unacceptable," shouted one homeowner. "Sharon Hendricks caused this disaster, and now we all have to pay for it." "I agree," said another. "She should be personally liable." Sharon, still HOA president until the special election could be held, tried to defend herself. "I was acting in my capacity as an HOA officer. I made a judgment call based on the information I had. "You had information that there was a property line dispute, and you ignored it," someone else yelled. "That is not a judgment call. That is negligence." Tom Bradley stood up. "I move that the HOA board consult with an attorney about whether we can recover the damages from Sharon Hendricks personally." The motion was seconded and passed overwhelmingly. I did not take pleasure in watching Sharon's world collapse, but I could not deny a certain sense of justice. She had been so arrogant, so certain that the HOA's authority was absolute, and now she was facing the consequences. The special election was held 3 weeks later. Sharon did not even try to run. A retired engineer named Patricia Collins won the presidency, running on a platform of transparency and accountability. One of her first acts was to commission a complete survey of all common areas in the subdivision to prevent any future boundary disputes. Patricia called me personally after taking office. "Mr. Zimmerman, I want to apologize on behalf of the HOA. What happened to you was wrong and it should never have occurred. We are going to make this right." "I appreciate that," I said. "I never wanted to be at war with my own HOA." "I have been reviewing the restoration plans," Patricia continued. "Our landscape architect says that if we work with a specialist in native plantings, we can actually improve on what was there before. We want to do this right, not just meet the minimum legal requirements." True to her word, the HOA hired a restoration ecology company that specialized in native plant communities. They came out to assess the damage and develop a comprehensive restoration plan. The lead ecologist, a woman named Dr. Sarah Kim, spent hours talking with me about what Jessica and I had planted and what we had hoped to achieve. "We can do something really special here," Dr. Kim said. "If we do this right, it will be better than before, and it will serve as a teaching example for the whole community about the importance of native plantings." The restoration work began in early fall, the best time for establishing native plants in North Carolina. The crew first had to repair the damage from the excavation, bringing in structural soil and building retaining walls to prevent erosion. Then they carefully graded the slope to match the original contours. The planting phase was like watching an artist at work. Dr. Kim and her team placed each plant with consideration for how it would grow and interact with its neighbors. They used a mix of mature specimens and smaller plants, creating an instant visual impact while allowing for natural growth patterns. They installed a temporary irrigation system to help establish the plants, along with erosion control blankets made from natural fibers. Signage explained what was being done and why native plantings were important for pollinators, birds, and soil health. Tom came over one afternoon while I was watching the work. "This is turning into something really positive," he said. "Who knew that Sharon's screw-up would lead to this?" "I would rather have the original plantings and no lawsuit," I said, "but I have to admit, they are doing a beautiful job." As the weeks passed, the slope began to transform. The plants settled in, and the irrigation system kept everything healthy. Dr. Kim visited weekly to check on progress and make adjustments as needed. Meanwhile, the legal proceedings continued. The HOA's attorney had filed a motion asking the court to apportion the damages between the HOA and Sharon personally, arguing that she had exceeded her authority and acted with gross negligence. Sharon hired her own attorney to defend against that claim. I did not need to be involved in that fight. My attorney fees had been paid by the HOA as part of the preliminary injunction order, and the restoration work was well underway. I was ready to let the HOA and Sharon battle it out between themselves. However, the court had other ideas. Judge Morrison scheduled a hearing to determine whether Sharon's actions rose to the level of criminal misconduct. The district attorney's office had reviewed the case, and was considering charges of property damage and fraud. At the hearing, the DA presented evidence that Sharon had deliberately concealed information about the property boundaries from the HOA board and from the construction company. The meeting minutes that James Patterson had provided showed a pattern of deception and manipulation. Your Honor, the assistant district attorney argued, Mrs. Hendricks knew or should have known that she was authorizing construction on private property without permission. She suppressed information about property boundaries, dismissed legitimate concerns from fellow board members, and proceeded with construction even after being presented with survey evidence. This goes beyond poor judgment. This is criminal property damage. Sharon's attorney argued that she had been acting in her capacity as HOA president and that any mistakes were civil matters, not criminal ones. Judge Morrison took the matter under advisement, saying she would issue a written ruling within 2 weeks. Those 2 weeks were tense. The neighborhood was divided between those who thought Sharon should face criminal charges and those who felt she had been punished enough by losing her position and facing civil liability. I honestly did not know what I wanted. Part of me wanted to see her held fully accountable for the damage she had caused. But another part of me just wanted to move on with my life. The judge's ruling came down on a Friday afternoon. Judge Morrison found that there was sufficient evidence to support criminal charges of second-degree property damage, a felony in North Carolina when the damage exceeds $2,000. The case was referred to the district attorney for prosecution. Sharon was arrested the following Monday. The local news covered her perp walk, and the image of her in handcuffs being led into the police station went viral on social media. The comments ranged from sympathetic to gleeful, depending on people's experiences with HOAs. I felt sick watching it. No matter what she had done, seeing another human being humiliated like that was difficult. Sharon posted bail and was released pending trial. Her attorney immediately began plea negotiations with the DA's office. The case dragged on for months, during which time Sharon became something of a cautionary tale in HOA circles nationwide. Articles were written about the case in property law journals and HOA management publications. Eventually, Sharon accepted a plea deal. She pleaded guilty to 1 count of property damage and was sentenced to 3 years of supervised probation, 200 hours of community service, and restitution of $40,000 to the HOA to help cover the restoration costs. She also agreed to never serve in an HOA leadership position again. The criminal case closed that chapter, but the civil lawsuit between the HOA and Sharon continued. The HOA's insurance company, having initially denied coverage, eventually agreed to a partial settlement that helped cover some of the costs. The HOA sued Sharon for the remainder, and after months of litigation, they reached a settlement where Sharon agreed to pay $25,000 over 5 years. Through all of this, life went on. The restoration of my slope progressed beautifully. By the following spring, the native plants had established themselves and began blooming. The purple coneflowers that Jessica had loved were back, along with black-eyed Susans, butterfly weed, and native grasses. Dr. Kim and her team installed a small educational sign at the bottom of the slope near the trail, explaining the native plant community and its benefits. It became a popular stop for walkers and joggers, many of whom told me they appreciated learning about native landscaping. Patricia Collins proved to be an excellent HOA president. She instituted regular financial audits, published detailed meeting minutes, and created an online portal where homeowners could access all HOA documents and see how their dues were being spent. The neighborhood felt less like a battleground and more like a community. Tom Bradley and I became good friends, often grilling out together and watching football games. He introduced me to other neighbors I had not really known before, and I began to feel more connected to the community than I had in years. One evening in late spring, about 18 months after the whole ordeal began, I was sitting on my deck watching the sunset paint the sky orange and pink. The slope below was covered in blooming wildflowers, and I could hear songbirds settling in for the night. My phone rang. It was Martin Brooks, my attorney. "Brian, I wanted to let you know that the HOA's lawsuit against Sharon was settled today. She made her first payment, and barring any issues, the matter is finally closed." "That is good to hear," I said. "How are you doing? How is the slope looking?" "It is beautiful, better than I could have hoped, honestly. I am glad something good came out of all this." "That was a hell of a fight." "It was. Thank you for everything, Martin." After hanging up, I walked down to the slope and stood among the flowers. The evening light made everything glow, and butterflies danced between the purple coneflowers. I thought about Jessica and how much she would have loved seeing this. The restoration had turned into something more than just replacing what was lost. It had become a living memorial to her and to the importance of standing up for what is right. A jogger stopped on the trail below. "Beautiful garden," she called up. "Thank you," I said. "It has been quite a journey getting it to look like this." As I walked back up to my house, I reflected on everything that had happened. The experience had been exhausting, expensive, and stressful. But it had also taught me important lessons about community, about standing up for yourself, and about how something destructive could be transformed into something beautiful. The next morning, I woke to find an email from Patricia Collins. The HOA board wanted to present me with a Community Service Award at the next monthly meeting for helping expose problems in the HOA's governance, and for my willingness to work collaboratively on the restoration project. I smiled and typed back a polite acceptance. A year and a half ago, I never would have imagined attending an HOA meeting voluntarily, let alone receiving an award from them. The meeting was held on a Tuesday evening, and the community clubhouse was full. Patricia called the meeting to order and quickly moved through the routine business before getting to the special presentations. "As many of you know, our community went through a difficult period last year," Patricia began. "A property dispute led to litigation, leadership changes, and a lot of hard feelings. But I want to focus tonight on how we moved forward from that. Brian Zimmerman could have remained angry and adversarial. Instead, he worked with us to create something positive. The restoration of his slope has become an educational asset for our entire community, and his willingness to engage constructively with the new board has helped us rebuild trust. Brian, would you come up here?" I walked to the front, feeling self-conscious with everyone watching. Patricia handed me a plaque. "On behalf of the Meadowbrook Hills Homeowners Association, we want to thank you for your patience, your integrity, and your commitment to making our community better." People applauded, and several came up afterward to shake my hand and thank me. It was a surreal moment, considering how hostile things had been just a year earlier. After the meeting, James Patterson approached me. He was the former board member who had raised concerns about the property boundaries and been shut down by Sharon. "I want to apologize," James said. "I should have fought harder when Sharon dismissed my concerns about the survey. I knew something was wrong, but I let her bully me into silence." "You tried," I said, "and your meeting minutes were crucial evidence. Do not be too hard on yourself." "Still, I feel responsible. If I had pushed harder, none of this would have happened. Maybe, or maybe Sharon would have just found a way to exclude you from the process entirely. People like her do not listen to reason. Sometimes the only way to stop them is through the courts." James nodded thoughtfully. She called me last week, asked if I would write a character reference letter for her probation officer. I told her no. How did she take that? Not well. But I am done enabling people who abuse power. That is part of why I joined the new board. Patricia asked me to serve as treasurer, and I accepted. We are going to make sure the finances are transparent and that nobody can pull what Sharon did ever again. Over the following months, I watched as the neighborhood continued to heal and improve. The HOA completed its comprehensive survey of all common areas, which revealed 2 other minor boundary discrepancies that were resolved amicably with affected homeowners. The new board instituted term limits for officers and created a conflict resolution process for disputes before they escalated to legal action. My slope became a source of pride for the neighborhood. Dr. Kim conducted educational walks in the spring and fall, teaching interested residents about native plants and sustainable landscaping. Several other homeowners began converting portions of their lawns to native plant gardens, creating pollinator corridors throughout the subdivision. I started dating again, something I had not thought I was ready for. Rebecca Hart was a teacher I met at a native plant workshop Dr. Kim hosted. We bonded over our shared love of gardening and the outdoors. She understood about Jessica and never tried to compete with her memory. Instead, she appreciated that love does not end just because someone dies. Rebecca was there with me one afternoon when we spotted Sharon at the grocery store. She was in the produce section, looking tired and older than I remembered. Our eyes met briefly and I saw a flash of something, embarrassment maybe, or regret. She quickly looked away and hurried to another aisle. "Was that her?" Rebecca asked quietly. "Yeah. Do you think she learned anything from all this?" I thought about it. I hope so, but some people never do. They just feel sorry for themselves and blame everyone else. That must be an exhausting way to live. I imagine it is. We finished our shopping and left. I never saw Sharon again, though I occasionally heard updates through the neighborhood grapevine. She and her husband sold their house 6 months later and moved to another state. Some said they left to escape the shame. Others said her husband got a job offer. Either way, they were gone, and the neighborhood moved on. The legal bills were finally all settled 2 years after the initial confrontation. The HOA had paid over $150,000 in total costs, including restoration, attorney fees, and settlements. The special assessment they had levied on homeowners was painful but manageable, and it served as an expensive lesson about the importance of proper oversight and due diligence. For me, the financial impact was minimal. My attorney fees had been recovered, and I received a small settlement from the HOA to compensate for the stress and inconvenience, though no amount of money could truly make up for the destroyed plantings and the months of conflict. The emotional toll took longer to heal. For months after the injunction was granted, I found myself constantly anxious, jumping every time I heard machinery or saw someone walking near my property. It took therapy and time to work through that trauma, but gradually, I found my peace. The slope bloomed each spring, more beautiful each year as the plants matured and spread. Rebecca and I got married in a small ceremony on my deck, surrounded by friends and family, with the wildflower slope as our backdrop. She moved into the house, and we began building a life together. 3 years after the initial confrontation, Dr. Kim contacted me with an interesting opportunity. A regional conservation organization wanted to feature my slope in a documentary about suburban habitat restoration. They were particularly interested in the story of how destructive action by an HOA had inadvertently led to the creation of a model native plant community. I agreed to participate, and the film crew spent several days at my property, interviewing me, Rebecca, Dr. Kim, and Patricia Collins. The resulting documentary, titled Common Ground, won several awards at environmental film festivals and was used as an educational tool by HOA management companies nationwide. The irony was not lost on me. Sharon's attempt to build a parking lot on my property had ultimately created something far more valuable, a teaching tool that would influence how HOAs and homeowners thought about property rights, environmental stewardship, and community governance. One afternoon, while being interviewed for a follow-up piece about the documentary, a reporter asked me if I had any regrets about how I handled the situation. I thought carefully before answering. I regret that it had to get ugly. I regret the stress it caused for everyone involved. But I do not regret standing up for my property rights. If I had let the HOA get away with it, they would have learned that they could do whatever they wanted without consequences. Sometimes you have to fight, not because you want to, but because the alternative is worse. What advice would you give to other homeowners facing similar situations? Document everything. Know your property boundaries. Read your HOA covenants and bylaws. Attend meetings. And if you are in the right, do not back down just because fighting is hard. There are too many Sharon Hendricks in the world who count on people being too tired or too afraid to stand up to them. The interview aired during a special on property rights disputes, and I received dozens of emails from people thanking me for speaking out and sharing their own HOA horror stories. It was both validating and depressing to realize how common these problems were. As time passed, the story became part of the neighborhood's collective memory, the cautionary tale told to new residents as an example of what could go wrong when HOA boards operated without proper oversight. The current board used it as a teaching moment, explaining how they had reformed their processes to prevent similar incidents. 5 years after everything began, Rebecca and I hosted a spring gathering in our yard. Friends, neighbors, and even some former adversaries came to enjoy the blooming slope and celebrate the garden that had grown from conflict. Patricia Collins gave a short speech thanking everyone for their patience during the difficult period and highlighting how far the community had come. Tom Bradley, beer in hand, pulled me aside. "You know, in a weird way, Sharon did us all a favor. The HOA was broken and nobody wanted to admit it. She pushed things so far that we had no choice but to fix it. The changes Patricia made would never have happened without that crisis." "That is a generous interpretation," I said. "Maybe. But look around. People are actually talking to each other. The HOA is transparent. We have a native plant community that is bringing in wildlife from miles around." None of that would have happened if Sharon had just been competent enough to check property boundaries before building. He had a point. Sometimes the worst things led to unexpected positive outcomes. It did not excuse what Sharon had done, but it provided some context for understanding how life works. Out of destruction can come creation. Out of conflict can come community. As the sun set that evening, painting the wildflowers in golden light, I stood with Rebecca and watched our guests mingling on the slope that had caused so much trouble. Butterflies danced between the flowers. Birds sang their evening songs. Children ran and played, their parents cautioning them to watch the plants. It was hard to believe that this peaceful scene had started with orange construction cones and an excavator tearing into the hillside. Hard to believe that something so destructive had been transformed into something so beautiful. Rebecca squeezed my hand. "What are you thinking about? Just how strange life is. How you can never really predict where you will end up. Any regrets?" I thought about Jessica, about the flowers we had planted together that had been destroyed and then reborn in a new form. I thought about the fight with Sharon and the HOA, the stress and the anger and the eventual resolution. I thought about meeting Rebecca and building a new life while honoring the old one. No regrets, I said finally. Just gratitude for where I ended up, even if the journey was harder than it needed to be. As darkness fell and our guests began to leave, I looked down at the slope one more time. Somewhere in those shadows, purple coneflowers were closing their petals for the night, native grasses were settling in the evening breeze, and the whole ecosystem was preparing for another day of growth and life. Sharon had tried to build a parking lot. Instead, she had inadvertently helped create a legacy, a living testament to the importance of protecting what matters, standing up for what is right, and finding beauty even in the most difficult circumstances. The slope would bloom for years to come, long after everyone had forgotten the details of the legal battle, but hopefully not the lessons it taught about community, accountability, and the courage to fight for what you believe in.